An impaired driver has injured you or killed someone you love. The driver was sentenced to more than 2 years in prison, but they will not serve their entire sentences in prison. As a victim or survivor, you may request information about the offender, like where they are serving their sentence or when they are eligible for early release. You may be able to participate in parole hearings and submit a victim statement. This video will answer frequently asked questions about federal parole for impaired drivers who receive a sentence of 2 years or more. The sentence was not long enough, and the offender gets out early. Why do impaired drivers not serve their entire sentence?
It can be difficult to accept that someone who injured you or killed your loved one is not going to spend their entire sentence behind bars. It may feel like they're getting out early and your suffering is still ongoing. Offenders are released early because it can be safer to release them before the end of their sentence with conditions and supervision. The alternative is to release someone at the end of their sentence with no controls or supervision. While on conditional release, the offender is supervised and can be returned to prison if they violate their conditions.
I was very surprised at how soon he'd be able to be released for all the different passes that he was eligible for. After killing and hurting so many people at once, he'd be allowed to just go out.
Doesn't the parole board care about victims and survivors?
The parole board's job is to determine if offenders can be safely released into the community. Their focus is the risk to public safety. In making its decision, the board looks at the offense, the driver's prior criminal history, risk assessments, plans for release, and so on. The parole board does not consider the length of the sentence, whether the offender has been punished enough, or whether they have spent enough time in prison. Because many impaired drivers do not have prior criminal records, they may be considered to be low risk and may be released on parole.
How do I find out what happens to the offender after they are sentenced?
You have the right to request information about the impaired driver. You can contact the Correctional Service of Canada or the Parole Board of Canada by phone or online to register to receive information.
I decided to receive information directly from the Parole Board of Canada and Corrections Canada as well, because I want the facts. I want to know what's going on in terms of the offender and her movements and her life, because it could impact ours. I don't want her anywhere near myself or our children, nor does my father-in-law.
What information can I get?
You may find out where the offender is serving their sentence, when they are eligible to apply for release, their progress while in prison, or if the offender has applied for temporary or work release passes.
When can offenders apply for parole?
In general, offenders are eligible to apply for full parole after serving 1/3 of their sentence. The offender can apply for day parole 6 months before full parole. If the offender is not released on parole, they will be released after serving 2/3 of their sentence.
When lawyers and Corrections Canada read the sentencing, they could do some pretty quick math in terms of when the eligibility dates would fall, in terms of the offender applying for day parole and full parole, and when the sentence would be served in its entirety. So it came as no surprise to me, although when she did apply for day parole and full parole, it seemed to come as a big surprise to the general public. They were very surprised that somebody could apply so early.
They said the offender is applying for day parole. What is that?
Generally, offenders on day parole stay at a halfway house. They can be in the community during the day to work or access treatment, but they stay in the halfway house at night. Offenders on full parole may live in the community full-time.
Can I submit a statement?
Yes, you may submit a statement in writing, and you may choose to read it out loud during the parole board hearing. If you choose to read the statement, you must submit a written copy. You may also submit your statement via video or audio recording. Please take note that the offender will be given a copy of your statement.
I read my statements at the parole hearings because I wanted the offender to hear what he had done in my voice, the impact that it had on me. And the best way I could do it was to read my statement. So to honor my family, to honor my role as their mother, to honor my loves, I stood there and I read it each time.
I did a statement for sentencing. Why do I have to write another one?
The parole board will have a copy of your statement if you did one at sentencing. You are not obligated to do another statement, but you can do a new one if you wish to.
What should I say?
Statements should address any emotional, financial, or physical impacts of the crime and focus on the risk the offender presents at the time they will be released into the community. You may express your opinion on release. Your statement can also include a request for special conditions to be imposed on the impaired driver if they are released. For example, you may not want the impaired driver to contact you or your family or return to your community. Your statement should be addressed to the parole board members, not directed to the offender.
I do not want the offender to get parole. Will my statement help?
Parole boards consider a lot of information from various sources, including sentencing reports, psychological assessments, reports from parole officers, letters from the community, and so on. Your statement is one piece of information. Victim statements generally will not be the deciding factor in whether or not the parole board grants release, as their decision is based on risk.
We approached the parole hearing knowing that no matter what we said, it really wouldn't have an impact on the decision on whether or not she would gain release. That decision was about her behavior inside the prison. But for our family, it was important that we be heard. The parole board has to listen to the voices of victims. So that door is just ever so slightly ajar. And we wanted to stick our foot in that and be heard and let people understand how somebody's crimes can still impact and re-victimize people years after they're committed.
Where can I get help preparing my statement?
MADD Canada thinks your voice is important for the parole board to hear. We can provide support while you prepare your statement, and we can also provide sample statements.
Can I participate in the parole hearing?
Yes, you may participate in the parole hearing. You will have to complete the form Application to Observe a Parole Hearing, which you can find on the parole board's website.
Not only did I prepare a statement for the parole hearing, but so did Brian's father, Gus. So did Brian's sister and Brian's brother and other members of the family. Everybody wanted to be heard.
Where will the hearing be held?
Hearings will take place at the prison where the offender is serving their sentence. If you are able to attend the hearing in person, you will be screened by security when you enter the prison. The room that the hearing is held in may be small, and you may be in close proximity to the offender. The Department of Justice has a fund to provide financial assistance for things like travel and accommodations to victims who have registered to attend a parole hearing. For more information, you can email the Department of Justice at parolef@justice.gc.ca.
What should I expect?
It may be difficult to hear the offender, possibly for the first time, speak at length about the crash. They may say things that you think are untrue. They may express remorse that you may or may not believe is genuine. They may accept responsibility for their actions, or they may minimize what they did. It can be a very emotional and frustrating experience.
So I would absolutely encourage you, if you think you can do it, to do it. Just be aware that, you're going to be in very close proximity, and that's really, really hard. Make sure you bring someone with you that you can count on to catch you literally if you fall, to support you. Whether it's a hand on your back or holding your hand as you're doing or ready to take over if you can't speak. Have somebody by your side who can do that for you.
Do I have to attend the parole hearing?
No, there is no obligation to register to receive information about the offender, prepare a statement, or attend any hearings. You need to make the best decision for you, and that may mean not getting involved in the parole process. It can be a difficult and painful experience.
What if the impaired driver was sentenced to less than 2 years?
MADD Canada can provide information on your options if the impaired driver was sentenced to less than 2 years. Please do not hesitate to contact us.
MADD Canada has just been there. They're always a phone call away or an email away. They find out information and they give it back to you, which as a victim is super important.
Thank you for watching this video. Victims and survivors of impaired driving are MADD Canada's #1 priority, and we hope this video was helpful. If you have any questions about the videos or MADD Canada's services for victims and survivors, please call us at 1-800-665-6233 or visit our website at madd.ca.